some movement in her appeal. So, right? I know. Sorry, I should have said jump scare. This is my favorite picture of her because it looks like who she actually is. That's the real Lori. That's the murderous, hateful, cold Lori. All of the
Mm-hmm.
other smiling, flipping her hair.
Yeah.
That's the facade. This is the murderer.
Mm-hmm.
Okay, so
This is
here's
the
what's happened.
narcissist having a fit, who
Yes,
has just
yeah, not
recently
not
been
getting their way.
told no. Yeah.
Yeah. So here's what's happened. Her defense appellate attorney team has now filed her reply brief with the Idaho Supreme Court.
Mm-hmm.
So they filed their appeal. The state filed their response. Now they've filed their reply. That completes the filings for the
Yeah.
appeal. That means it all goes to the Supreme Court justices of the state of Idaho now. So I want to talk to you about what was in the reply brief and then talk to you about what the process is now,
Mm-hmm.
um, about how does her appeal get reviewed. So something that's really important to note about this appeal is that this appeal does not attack the trial itself, hardly at all, slightly, but it's much more about what are called structural errors. And structural errors are things like constitutional rights violations.
Yeah.
Structural errors, when they're found to be legitimate, which is exactly what's happening with Letecia Stauch, and we'll talk about that. Structural errors are things that happen that can violate someone's constitutional rights, and it doesn't have anything to do with what the jury found. So it's not about did something prejudice the jury, did someone lie to the jury. It's not about that. It's about the structure of the proceedings leading up to the trial are faulty. Therefore, the trial should never have happened. It's much more serious. Now, I say that, but please know that that doesn't mean that she's going to win this. And I'm going to talk to you about some of the stats in Idaho to give you some ideas. But this is they're really what they're leaning heavily on are Sixth Amendment rights and 14th Amendment rights that the defense is saying were violated.
Yeah.
So the Sixth Amendment is the right to counsel. It's the right to counsel, right to effective counsel, right to retained counsel of choice.
Mm-hmm.
So they are attacking the removal of Mark Means from her defense team.
Mm-hmm.
Who knew Mark Means was going to feature again in this story so heavily? But that's really that's their top argument.
Oh, I think that's Mark Means' wet dream right here. Yeah.
I think probably, yeah. So
He
we
will be
know,
vindicated. Hopefully not.
right?
But
Probably not, but we know why Mark was removed. The trial court determined that there was conflict. There was a risk of conflict because of the overlapping issues representing Chad Daybell and briefly and Lori Vallow, which could indicate possible divided legal interests, and that there was concern that Means could not fully protect both legal positions because the he said, she said situation in this case. So the judge removed Means before the trial moved any further. And what's interesting is that the prosecution had been lobbying to have Means removed for a long, long time before Judge Boyce uh, actually had a hearing on this and removed him. Like it had been
mm-hmm.
going on, well, since the very beginning of this case,
Yeah.
as soon as they found out that he had, in fact, represented Chad Daybell briefly.
Right.
Some of the things that the Sixth Amendment does, it also gives you the right to represent yourself. As we know, she exercised that heavily in Arizona. But it
Mm-hmm.
gives you the right to retain poor counsel, counsel that is not recommended. It gives you the right to make a shitty choice in your own defense.
Yeah.
Because that was part of the issue around
Mm-hmm.
Means, was there was a lot of incompetence.
Yeah.
We have to remember, though, that element of Lori being found incompetent. And all of this happening while guess who was in a hospital? And And there are questions around that.
We've always had questions around that. It does not surprise me that this comes up.
Because she was not represented at that time and could not give her own defense in why she wanted to keep Means, and that's a concern.
Yeah.
One thing I will say, because I really appreciated it about Judge Boyce all the way through her trial, was how very carefully he preserved the record and how very careful he was about making clear legal explanations for all of the decisions that he made. So basically, to give her a new trial based on that decision, the Supreme Court would have to decide that Judge Boyce erred in removing Mark Means. Not just in removing him, but in how he was removed, while she was still found incompetent, while no one else was there to defend what she wanted, those kinds of things. What the defense is arguing is that there was no actual conflict proven. I think that's not true. I mean, he literally put it on his Twitter, if we all recall, that he represented Chad Daybell.
Yeah.
That it was only a possible future conflict, that it wasn't actually a current conflict, but that this was done prior to there being a problem. And that constitutional rights should not be overridden based on speculation that this would create a problem down the road. The defense says that Lori should have been allowed to knowingly waive the conflict. Unfortunately, at the time, she was in a state hospital found to be incompetent and couldn't have waived the conflict. Their position, removing retained counsel, is one of the most serious judicial interventions possible. Here's why appellate courts worry or have concern about this. Counsel of choice issues matter a lot because once a chosen lawyer is removed, that constitutional choice cannot be restored later. Even excellent substitute counsel does not erase loss of original legal choice. This is why legal analysts view this as Lori's strongest issue. And so that's why it's top of the heap. She had every right to think that he was her blue-eyed baby boy. Even though we all know that was fucking crazy. Technically, she does have that right.
Yeah.
So the second Sixth Amendment issue is that Means was not fully allowed to participate during hearings deciding whether he would be removed, and that Lori effectively lacked full counsel during a critical stage. Like, she didn't have anyone representing her to say, hey, no, this is the attorney I want.
Yeah.
A critical stage, this is important because they're saying that he was removed at a critical stage, which any hearing where major rights are being shaped is critical stage. And of course, we have this overlapping conflict here. So the defense is saying that deciding whether a defendant loses chosen counsel clearly qualifies as a critical stage claim. So defense says this is a structural error, that if counsel is denied during a critical stage, courts sometimes classify that as a structural constitutional error, which could mean everything that happened after that was tainted by this constitutional violation. There you go. Excellent. Okay. Then
we've gotten mileage out of this graphic over the years.
Absolutely. Then there's a 14th Amendment due process claim. And this was I feel like this was addressed very significantly over time in court. And it was the idea that proceedings continued while Lori was in the hospital. Her case was stayed, but there were still hearings and decisions that were being made that did impact her case. And there was a lot of concern because their cases were joined. And the defense is basically saying, both cases should have been stayed until she was out of the hospital and found competent to participate,
Mm-hmm.
because they hadn't severed these cases. They didn't
Or the
get severed
cases should
until
have been
right
severed.
before.
If they
Yeah,
wanted to move forward with Chad, they should have severed. I've always
right.
questioned this and wondered
I
how
have
that was
to.
okay.
I have too. And, I know that multiple times it was brought up by the prosecutor, it was brought up by the defense, it was brought up by the
Mm-hmm.
judge. Should we be having this conversation? Should we be having this hearing while Lori is considered incompetent? So there's
Mm-hmm.
questions there about if there were decisions made in her case that she wasn't actually able to assist with.
Mm-hmm.
Um, so that's a due process argument, that is the other constitutional violation in this
Mm-hmm.
trial.
God.
And of course, the state says that they followed all competency procedures properly, and that no actual prejudice occurred. I think that there was definitely awareness um, that this was a concern, and that was on the record multiple times. And so I do think that there were attempts to make sure that that didn't happen, except that it kind of did.
Mm-hmm.
And because these cases were joined at the time. So
Mm-hmm.
I don't know. Remember that either there's a structural violation in the case that could result in some action by the Supreme Court, or there was a prejudicial issue for the jury that could result in an action. That's basically what they're looking at here. Did
Mm-hmm.
either of those things occur?
Yeah.
Because the other part of the 14th Amendment due process claim is the 404B prior bad acts that were allowed in. All the stuff,
Mm-hmm.
all the things that happened in Arizona, the prior deaths, family events, the religious beliefs, the emotionally inflammatory history, um, and that the defense is saying that those things risked turning the trial into character judgment instead of charge by charge proof. We don't know.
Yeah.
I mean, that was addressed a gajillion times in the trial.
Mm-hmm.
Prior to the trial, it was addressed over and over and over again. The state's uh, standpoint was that this is part of a common scheme. This is
Yeah.
part of proving the conspiracy in her case, and it was allowed by the judge. And so again, the Supreme Court has to decide, did Judge Boyce fuck up? Should he
Yeah.
not have allowed that? I think there's a ton of evidence that they should have. She also hits on speedy trial, which
Oh my
weak,
God. More of
total weak
that.
sauce there. We know it is
Right.
total weak.
She's the one that ended up in the hospital. There's nothing they could do about that. Yeah.
Yeah. So you can go read it. The link to it is in our um, show notes. I didn't put the whole thing in because I didn't want to read the whole thing to you. It's very boring and long. But those are basically the arguments. And it looks like that the strongest argument was the removal of Mark Means a violation of her Sixth Amendment rights.
Mm-hmm.
Let me tell you a little bit about the Idaho Supreme Court. So this means that their briefing is complete as far as the outside parties are concerned. Now it's their
Mm-hmm.
job to look at this case and decide what they're going to do. The Idaho Supreme Court usually takes 3 to 9 months to decide a criminal appeal. Large murder appeals can even take up to a year or longer. So, as we know, the OG voluminous trial
Mm-hmm.
could take a long time.
Yeah.
Now, these things are filed on Lori's docket. This is Lori's attorney requesting oral argument before
Mm-hmm.
the Supreme Court, and this is the Fremont County prosecutor requesting oral argument as well.
Wow.
Here's the thing: they can ask all they want. It doesn't
Mm-hmm.
mean that they will get oral argument.
No.
They might get oral argument, or they may just rule on paper.
Mm-hmm.
They don't have to do oral argument. They only do oral argument if they feel like they need it. If they're not
Right.
quite sure, if they're not in agreement, then they want to hear the oral argument.
Yeah.
So if Lori's case shows up on the Supreme Court's calendar, and our court travels all over the state, um, it's possible there would be all of their hearings are streamed. So if there is
Mm-hmm.
oral argument, we will be able to stream it.
Absolutely.
Uh,
Yeah.
if they happen to do it while they're here in our area, we could even go.
Mm-hmm.
Um,
They were here
but
in
we won't
Rexburg
know.
not that long ago at BYU,
Yeah, they're
Idaho.
going to be in Rexburg again in like May or June, but
Are
that's
they?
really
Okay.
soon. I think that's
Well,
really
too
soon. I
soon
was
for
looking,
this.
I
Yeah.
was looking, and there's there's a date, but these are already set with cases. So this would be later in their year to
Mm-hmm.
add this case if they were going to.
Yeah.
I don't know if you've ever watched Supreme Court testimony before, but you get a certain amount of time, like 30 minutes.
Yeah. It's not a
And the
lot.
whole time each attorney is talking, the justices are interrupting them with questions because they have
Mm-hmm.
specific information they want to get out of them in a very
Mm-hmm.
tight timeline.
Yeah.
So, because the timeline would be so tight, they're likely going to hit on those Sixth Amendment issues much harder than
Mm-hmm.
anything else
Yeah.
because that's their strongest case.
Mm-hmm.
But we don't know. I'll keep a close eye on the state Supreme Court's docket so that we can let you know if it gets added. We won't really know unless it just shows up on their calendar.
Yeah.
Um, and if it doesn't show up on their calendar, they might just issue a ruling too.
Mm-hmm.
It really is very much up to them. Uh, they're not wanting to relitigate guilt.
No.
Really, what they have to focus on is whether the trial judge built a significant legal record,
Mm-hmm.
which, I mean, Boyce was exhaustive in
Yeah.
building the record,
Yeah.
and whether the procedures followed constitutional rules. So basically, did the trial judge have enough concrete evidence to remove Mark Means?
Yeah.
One thing that is pretty significant in this case is sealed records, because there are a lot of
Mm-hmm.
sealed records in Lori's case, as we know. But the Supreme Court gets to see those. And so it's very possible that there are things in those
That we
records
don't
that
know.
we
Yeah.
don't know that address directly any of these issues.
Mm-hmm.
So it's difficult to be sure if there's a conflict here or not because they can see more than we can.
Right. One
Just
tiny thing came up for me,
mm,
and it's a small thing, but in relation to Chad and Mark Means having access to Chad or his case and the conflict of interest that they argued.
mm-hmm.
When he was removed, it was right after he had filed that big, long, drunk at 3 a.m. kind of filing. Yeah, that was full of all the air quotes and the mistakes and,
Yes,
accusing the Mormon church as well as the state, as well as health and welfare of
yeah,
all colluding against Lori and all that crazy stuff. One of the
right.
things he included in that filing that we always thought was really weird was a letter from the Mormon church excommunicating Chad. Not
That's right.
Lori, Chad. And we were
Chad,
always like, how did he have that? Why did
how
he
did he
have
have that?
that? Those are super confidential documents, and he had to have been given that. But
Somewhere
again,
along
and
the
I know
line.
that's a small thing, but to me, that's just one small illustration of him having access to Chad in a meaningful way, or Chad's legal documents. And that's
Right.
all.
Yeah, who
That's a small
provided him
thing,
with
but
that?
right.
It's a good point. I think that's a great point. Um, and as far as like all the exchanges with health and welfare went in relation to Lori,
Hmm.
sealed. We have no
Yeah,
idea what any of
we
those
don't
things
know.
say.
Yep.
And maybe some of this is addressed further
I think
in
the
that
other thing that you
documentation.
have to consider, or that and maybe they don't, but that I would consider, is that Lori had already been declared indigent at that point and had already been assigned public defenders because she couldn't pay Mark because the money that
Right.
was paying for Mark was coming from Chad.
Right.
And that money dried up after Chad went to jail. And
But there's this
so,
other weirdness around that Chad was paying her attorney.
yes.
The financial conflict there.
Mm-hmm. Kind of plays into all of this. Absolutely. Good
Right.
point. But
Well, and this was still a death penalty case at that point, and so
yes.
she, because she was indigent, had to be assigned these death penalty certified attorneys.
Yeah.
If Mark Means had stayed on, he would have stayed on as third chair.
Yeah. He had already been bumped to third chair in this case.
Yeah,
Will
I
that
know. So
play into
that,
the Supreme Court's decision? I don't know.
I don't know, but
But
I mean, there's a lot of nuance here. I think,
yeah.
especially in this case. Here are some just overall stats as far as Idaho criminal appeals are concerned. 70 to 85% of appeals end in affirmance. And affirmance just means we uphold the original conviction, the end. 10 to 20% get a partial correction or remand. So that means maybe they make a slight change to something, a sentence possibly.
Mm-hmm.
What's it going to matter? What she got now? 7 life sentences, whatever.
Yeah.
Or there's some kind of memo to the judge, like, hey,
Mm-hmm.
this was not cool. You need
Yeah.
to adjust what you're doing. Verse plus out to everyone, like, hey, because of this case, we want to say
Mm-hmm.
this, and this about,
Yeah.
the future of cases like this, but it doesn't mean a new trial. New
Yeah.
trial is the absolute very last resort.
Oh yeah.
And it is 10% or less
Yeah. It
in
is.
Idaho criminal cases. It's
Yeah.
very rare. It's especially rare in murder cases in
Mm-hmm.
Idaho. Idaho does not want to overturn juries, and they do not want to overturn murder trials. They just don't.
Yeah.
It has to be really egregious for
Yeah.
them to do anything.
Mm-hmm.
So, don't worry too much, because
Yeah.
truly the things that generally have resulted in reversals, which means a new trial, are things like false testimony, counsel conflict, major jury instruction defects, and constitutional denial during critical proceedings.
Yeah.
So counsel rights are definitely the they're hitting that hard, because that's much more likely to be successful, but it's still pretty unlikely to be
Mm-hmm.
successful.
I wonder if the
Because
state will argue on the stuff that, they were meeting and having making decisions that applied to Lori. I wonder if they'll argue that her attorneys did go back and challenge those things. They were allowed to go back and challenge those decisions and file things, which they did do,
they did do,
and
yeah,
did get were heard and did receive rulings on. I wonder if that'll
yeah.
if that will weigh into the Supreme Court's decision on that topic.
It it may, on that kind of on the secondary due process issue.
Yeah.
If they find that Mark Mead's removal was in fact correct,
Mm-hmm.
then they can go look at, yeah, they did. They went and relitigated a bunch of stuff after the
Mm-hmm.
new attorneys were assigned
Yeah.
to ensure that her rights were protected.
Mm-hmm.
I feel like Boyce worked really hard to appeal proof this case. I think it
Mm-hmm.
is unlikely that she's going to get any traction here. But these are basically the arguments, and this is what they're attacking the hardest.
Mm-hmm.
They are not attacking in any way that the jury got this wrong, and they are
No.
not attacking the actual evidence of the case at all,
No,
which
this is
is
all
wise
procedural.
because, well, it is voluminous.
Mm-hmm. Mm-hmm. So Kristi had said she wondered what it would have been like if Means stayed on the case. And I'll tell you what it was like towards the end when Means got knocked down to third chair and suddenly we now have Archibald and Thomas on the case. They weren't talking. Means wasn't speaking to them. He wouldn't
No.
communicate with them. So he was filing all this wild shit that the other counsel didn't know anything about.
Yeah.
That whole big filing about the or that everyone was colluding against Lori and stuff.
Yeah.
They didn't know shit about that until after it was filed. And they were like,
Right.
it's just a thing that happened. It's like, we're not worried about it. There was, but what was happening basically is that there were two different lawyers that were trying to defend Lori's case because
Yeah.
Means basically refused to work with them.
It was real messy. So
Mm-hmm.
I mean, they've got a lot of justification that I don't know. I mean, I really don't think that this is going to happen. But like somebody
Mm-mm.
said, fine, just send her to Arizona and she can serve her life sentences there. Like, I mean, that's the other part of this is like, I mean, she's not ever
Well,
getting out of prison either
yeah, 'cause I
way.
don't know about you guys, but I thought her lawyer in Arizona was an idiot.
Yeah, yeah. Her lawyer in Arizona was a real jackass.
The question is, would Mark Means have done a better job defending Lori in Arizona than Lori did?
I mean, he had just as many spelling and grammatical errors as she did. Like,
Hmm.
I
She
don't
might have
know.
been a
That
better
doesn't,
writer, honestly.
might have
Yeah.
been. Alrighty. Well, that's what we know. And we will keep a close eye on the Supreme Court's docket and we'll let you know if this case turns up. I will
Yeah.
honestly be very surprised if there are oral arguments.
I would too.
Anything is
But can you
possible,
just,
but I doubt it.
let's just for one moment imagine a world where they retry her.
Oh, God.
Can you?
Because you know what would happen? She would represent herself. That's
Hmm.
exactly, she would represent herself.
Hmm. Yeah, Means moved. He's not coming back.
Yeah,
Yeah. Nope, she would definitely represent herself. It would
she
really be
would.
something. Yes, Means
It
was the
would.
one that was constantly whining about people being mean to him. He's the one
Yes.
in that hearing with Michelle Mallard as the judge here in the very, very beginning, and he had that stupid bandana on his face like some kind of deranged cowboy.
Yes.
He whined
Right
for
at the
two and a
beginning of
half
COVID.
hours about how mean the prosecution had been to him and how mean
Yeah.
the jail had been to him. It was the
Yes.
whole. It was all about him. It didn't have a damn thing to do with the defendant. Yeah.
Yeah. Hardly anything that he talked about did. It was always about him. It wasn't about the actual defendant in this case. It was
And
wild.
Michelle Mallard beat his ass. She had absolutely had it with him.
She had, yes, she took him down very hard. But
Mhm.
that bandana around his face, that was one of the funniest things I've seen in a long time.
Mhm.
In the
Letecia.
near or Letecia Stauch, in any, for any reason, really. However, we really have to talk about Letecia Stauch. Now, Letecia, if you remember, was the stepmother of 11-year-old Gannon Stauch. This happened in Colorado Springs, Colorado. On January 27th of 2020, she reported Gannon missing.
Mhm.
Um, Attention was pretty much immediately turned toward her as far as investigation was concerned because she was very inconsistent with her story and about what happened the day he went missing. They also found evidence that Gannon had been attacked inside her home. Um, Later, they would know that he suffered blunt force trauma, stab wounds, and a gunshot wound. The argument was that prosecutors said that she killed him, hid his body in a suitcase, drove it across multiple states, practically the entire United States, from Colorado to Pensacola, Florida, where she left the suitcase under a bridge.
Mhm.
They had all kinds of evidence against her: surveillance, cell phone data, blood evidence, evidence of her vehicle moving across the state,
Mhm.
false statements on her part. So,
Terrifying shit.
yeah, it was absolutely terrifying. She
Yeah.
tried to claim that she was not guilty by reason of insanity, arguing that she had dissociative identity disorder. The jury did not buy her defense, however, and convicted her in 2003 of first degree murder. First
Mhm.
degree murder of a child under 12 by a person in trust, tampering with a body, tampering with evidence. She was
Sh-
given life without
Yeah.
parole plus consecutive time for the tampering counts.
Right. I mean, she did way too much to cover up her crime
Oh,
to
she did.
think that anybody was going to fall for a mental health defense. I mean, come on.
Absolutely. She had plenty of consciousness of guilt.
Yeah.
However, the Colorado Court of Appeals came back today and they have reversed her conviction and they've ordered a new trial because the appellate court found what? Structural error. Remember, I explained about structural error with Lori.
Mhm.
Structural error. The structural error is that during jury selection, They had a juror who whose son-in-law worked as a deputy prosecutor in the same DA's office as was prosecuting this case. And they did not remove that juror from the jury pool, and that juror deliberated on her case.
Why? How could he
Why would
possibly
they
be
not have
worth
removed
it?
him?
Yeah.
Why? My God, they could have removed it. Basically, the judge and the prosecutor didn't think that that relationship was close enough to qualify as a conflict. The appeals court disagrees.
I would have disagreed.
Um,
That is a juror that is not worth it. Why?
Now, the defense also did not strike this juror, but the appeals court saying it doesn't matter, that the judge should have struck that juror
Mm-hmm.
automatically, that they shouldn't even have gotten all the way through the process.
Right. He should have never been anywhere near this.
Right.
Yeah.
Yeah.
Oh, God.
Now, yeah,
I'm
that
so
relationship
sad
creates
for Gannon's dad.
automatic legal bias or implied. It's called implied bias.
Yeah. Of
The
course. Of
so
course it does.
the defense tried to challenge this guy for cause, and the judge said no. The juror stays.
Mm-hmm.
Now, when they get their strikes, where they can strike for, they don't have to give cause. They still could have struck the juror, but they didn't.
Yeah.
I mean, honestly, was this um, a strategy on their part? It very well could have been,
Right.
because they knew full well that juror shouldn't have been on that jury.
They also knew full well they would lose this. The amount of evidence against her is staggering.
It is. It is. So she is not exonerated.
No.
They're not saying she's innocent. They haven't
No.
thrown out any evidence. They've just rejected the original trial. So the case goes back to the trial court now for new scheduling, new motions, possible renewed insanity litigation. Like, they have to do it all over again, full
Yep.
retrial, unless prosecutors can negotiate a deal.
Yep.
I mean,
There's a real shabusiness esque energy about Letecia.
oh, yeah,
Oh, she is crazy. She is so scary. But I'm
she
so
is.
horrified for Gannon's dad and his family that they
Oh,
have
I
to go through
know.
this again.
The
I cannot
family, to think that they have
imagine
to go through
how they
this
must
again.
feel today. Yeah.
Just sick. This prosecutor can appeal this.
They won't win it.
I doubt it's going to go anywhere, though. I'm pretty sure that if they've made a ruling like this, that they're not going to budge.
Yeah.
So she's not being released because it's very likely that retrial is going to happen. Now, this just happened today,
Right.
so we haven't seen a response yet out of the state.
Mm-hmm.
You know what they're gonna, how they're gonna, if they're gonna immediately appeal it first, and then potentially try to make a deal with her, or if they're like, hell no, we have a very strong case, we're going to take her back to trial. They
Mm-hmm.
could do any or all of those things, really.
Yeah.
So
Yeah.
it could mean that her life sentence is at risk.
Mm-hmm.
Could they agree to give her a shorter sentence or something?
Oh
That
my
could happen.
God. The thing is, with a new trial, she'll be found guilty again. The amount
She
of
will.
evidence against her is staggering. The fact that she ever
Yeah.
went to trial is bananas.
Yeah.
It just really
It is.
sucks that it has to happen.
Yeah. It really does.
Yeah.
It really does. So that's what we know. So
Yeah.
she's going right back on my trial tracker,
Oh, yeah.
because there will probably be some hearings here coming up, and we'll be keeping a very close eye on what the hell is going to go on here. But this
Yeah.
is huge news,
Huge. Shitty
and I
news. Yeah.
feel really bad for Gannon's family. They've got to be
Yeah.
heartbroken over this.
Do you remember her sentencing?
Yes.
The victim's impact statements were so gut-wrenching. I just
Oh
cannot
man,
believe they're going to be put in this position again.
no.
But I also can't believe they let that
Over,
juror stay. Why?
right, over a very easily remedied error. They could have gotten rid of that juror
Yeah.
so easily. Why would they? Why?
You could put practically anyone on her jury and they would find her guilty. Seriously. The
Right.
evidence was
Didn't have to
crazy.
stack the deck.
No. And you shouldn't, because obviously it's illegal and it puts us here. Yeah.
Can you get a calendar for trials? That's a great idea. I will figure out. Let me see what I can figure out. I have a calendar. How do
Mm-hmm.
I put a calendar up that's available so that you all can see it? That's a great idea. I will think about how to do that on our website.
Yeah.
It's a great
Right,
idea.
Rosanna. How is he even allowed to be called for jury duty at all? Wouldn't he have to recuse himself every time? Well, you'd think so. I'll bet he
You
was
would think.
surprised as hell he made it through.
Yeah.
He probably figured
Yeah,
he'd be
or a
there for
link in
one day
Discord.
and
That's
be
a good
home.
idea.
Yeah. Well, you should be able to share your Google Calendar.
Yeah, I could. Because I do have a Google Calendar that's just for trials. That's what I'll do.
Yeah.
I'll share it.
Yeah.
I will share it. That's a great idea. And then you all can see what I've got on the calendar, and it changes all the time. I'm always adding things.
Mm-hmm.
But yeah,
Well, and as
it's a
you
great
know, with
idea.
court changes all the time. So just because
It
something's
does
scheduled,
changes
it could
quickly.
easily change. Yeah.
Yeah. Oh, one last thing. Stacy Wondra has an
Yes.
arraignment hearing tomorrow. It's at 3:30 Mountain. I will be streaming it over on the Trials channel. Um, so he's back here in Idaho now.
Yeah.
We'll see. It may be very fast. I don't know if they'll discuss anything else, but I did catch that on his docket today. So we're gonna be now tracking that in Idaho.
Yeah. And Stacy Wonder, of course, is the man that's
Oh yes,
accused along with three, well, maybe three. No one's charged yet besides him, but they're all other people of interest. His wife and then two other people in the murder of,
Michael
help
Vaughn.
me, Michael Vaughn from
Yeah,
Fruitland, Idaho. We've talked about this case a lot. Yeah,
yeah, yeah. So we'll be following that very closely.
absolutely.